So, as I say, welcome to this seminar about B2B compliance, B2B compliance. Hopefully, what you'll take away from this is you'll have a good understanding of the kind of compliance that we're going to be talking about, whether you need to worry about it, and whether it's something that you need to consider in terms of your own business compliance and what you can do to comply. In terms of the kind of things we're talking about with regards to digital compliance, it's essentially four areas, although two of them you can say, well, security, the two security ones are the same, but essentially data protection. Of course, there's new data protection rules coming next year. The General Data Protection Regulation will replace the Data Protection Act in the UK. So that's a big growth area at the moment. Lots of businesses are beginning to think about how that's going to impact them. There's a lot of rules around privacy and what you can and can't do, particularly with data. But there's, privacy covers quite a wide range of things. The Privacy Electronic Communication Regulation rules apply to how you process data for marketing purposes, but also it controls things like cookie notices and how you use privacy notices on your website. And then the two security areas, the data security, and what I mean by that is security relating to internet-related services specifically. So it could be how you secure your website, right through to how you have a policy in place with regards to making sure your staff are fully aware of some of the risks of using social media in a work environment, for example. And then the cyber security, which is the typical cyber security. I don't do the technical stuff, so I'm not about fixing firewalls and virus checkers or removing viruses from computers. But I am about helping businesses understand the risks that they face from the use of the internet to their business, and particularly around training and educating members of staff so that they can mitigate the risk that they bring to a business. So in all four areas, actually, the key focus for what I do is around people, policy, and process. And those are the three key areas which can help any business make sure that they are compliant with the law and also protecting their business. So that's what we mean by digital compliance. So let's start on with data protection. As I mentioned, there's new data protection regulation coming next year. This is a European-wide piece of regulation. The important bit is it's a regulation rather than a directive, which means that it applies across the whole of Europe, and it's uniform across the whole of Europe. So it doesn't matter whether you've got a localized piece of legislation like we have, the Data Protection Act. This will completely supersede that member state legislation. It's coming into force on the 25th of May 2018, so we've got just under a year to be compliant, but it is a piece of law that's actually law right now. It was implemented last year, but there was a 2 years grace period in which all member states needed to get themselves ready. So the deadline, as I say, is the 25th of May 2018. In that fan diagram there, I've highlighted 10 particular areas that are changing. The key one, certainly if you're looking at a marketing point of view, is consent. The consent rules are changing, but there's a whole host of other changes coming. So I'll quickly run through all 10 of those. As I say, probably the most significant is consent, because that's one of the things that's changing. But just working from the left round to the right, the scope, as I mentioned, this is a European piece of legislation. This therefore covers the whole of Europe. It also expands the scope to mean any data relating to any EU citizen, so it doesn't matter even if you're out of the EU. So us, for example, leaving EU and what that might mean, we still need to pay attention to this piece of legislation, as do people in the States and elsewhere outside the European Union. And the other aspect of scope is it now includes regulation and controls around data processors. So in in a data protection sense, you have the data subject, who is the person whose data it is that you're holding, the data controller, who is the company or the organization that has collected the data of the data subject. And then in some situations, the data controller may also be a data processor, but you may have an external data processor who is a business that is processing the data, perhaps on behalf of the controller. The Data Protection Act didn't put all the pressure on the data controller and didn't regulate the data processor, but the General Data Protection Regulation, GDPR, that actually covers the data processors as well. So they've got quite a duty to make sure that they're compliant much more than they'd had in the past. Definition-wise, it's pretty much the same as Data Protection Act, but there's a particular mention of online identifiers. So if you collect data that, you know, like an IP address from a website or something like that, that can help identify an individual, then that is now clearly a piece of data from a data protection point of view. If your service or products are of interest to children or aimed at children, then there are new rules. There are specific parts of the GDPR relating to children's data. Specifically, you need to ensure that if a child is using your service and they are handing over data, that they're fully aware of what that data is for, and that means you need to write your privacy notices and your wording in a way that a child can understand. And you, therefore, you need to, so there's implied age verification as well in all of this, but also you need to get consent from a guardian. So the age verification bit comes in the fact you need to determine whether they're 16 or under. And if they are, then obviously your wording needs to be child friendly, and you need to get guardian consent too. And on the subject of consent, as I said, this is a big change. Consent is changing in the sense that you will no longer be able to have these pre-tick boxes, or taking the fact that somebody hasn't told you that they want you to not mark it to them as consent or implied consent. It has to be very clear and open about what you're collecting the data for, what you're going to do with it, who you're going to share it with, and it needs to be a positive opt-in. So you, as I say, pre-tick boxes are out, and you will need to have a clear statement as to what you're collecting data for, and a clear action on behalf of the data subject to actually consent to that processing. And there's a few other rules as well around you can't use you can't have insist on consent for the purposes of a service. So, for example, you can't say, well, I will only let you use my service if the condition of using my service is that I market to you, and the person has the right to say that that's not the case. So that's consent. You can't have consent without detriment to a service. And you also need to record the point at which you recorded consent and what consent was given, so that you have a record of that consent. Individuals' rights aren't changing in a general sense. They are the same as they are in the Data Protection Act right now. So these are rights like data subject access requests, which enables somebody to ask for a copy of all their data. And they've introduced two extra rights. The first is the right to be forgotten. So a data subject can say you can delete all of the data relating to them. That doesn't mean that they can delete all the data. You'd ask you to delete their billing data so that you can't bill them. Obviously, you need to have data for the purposes of delivering a service. But in a general sense, there is a right to be forgotten. And the second additional individual right relates to the request to have the data exported into a standardized format so that it can be processed or imported elsewhere. How you would need to consider how you're going to do that with the kind of data that you might be processing within your business. Certain kinds of businesses will need to have a documentation process that documents the way that they process the data. There's a new privacy by design, data protection by design, which is not too dissimilar from the existing privacy by design best practice that the Information Commissioner promotes as part of data protection. This is a rule that you must provide details. You must consider the privacy and the data protection implications of any new product and service that you might be designing. So data protection has to be at the heart of the design process as much as anything else. As I say, this is not really new to the UK because the Information Commission has been pushing privacy by design and privacy impact assessments, but the GDPR is very specific codification of that, and so so there's this principle of data protection impact assessments which need to be carried out. And moving swiftly around, carrying on this around that fan, data protection offers, that's DPOs. Certain sizes of businesses, particularly businesses that process lots of data or particular types of data, like sensitive data, they are now going to need to have a specific person within their business who deals with data protection compliance. So they would be called a data protection officer. They don't have to be an employee, and they don't have to have it as their only job, but they do need to be able to carry out their role without any problems. And so, for example, they can't be hindered at their approach or told that they're making their lives difficult. They have to be given full power to be able to get on and do the compliance work. And there's certain rules that set out what a data protection officer should and shouldn't be doing. And then the final 2 points are not particular new things, but some changes. Breaches, we've had a regime in the UK for a while around breaches and reporting breaches under certain circumstances, but these are codified now in the GDPR. And if there is a clear risk to the data having been breached to the individuals that data it is, then there's a good chance you're going to have to report it to the regulating body, which at the moment in the UK is Information Commissioner, and also the data subjects as well. And then finally, the fines, which is the stick that's being thrown about a lot at the moment. The top tier of fines can be anything up to 4% of global turnover or 20 million euros, whichever is the largest. So that's quite a hefty change from the sort of maximum fine that the Information Commissioner is likely to be able to use, which is £500,000 at the moment under the Data Protection Act. In fact, I think they've only Talk were the largest fine, and that was 400k. So 4% of global turnover or 20 million euros is clearly a significant shift. So that's something that's you'll probably already have heard of. So so that's a very fast run through of the General Data Protection Regulation. If you wanted more detail on that, then I do run some other webinars around GDPR in more detail. So look out for those. But moving on, we talked about GDPR and what that might mean going forward. In a business environment, so a business-to-business environment as opposed to business-to-consumer, there is a lot of sort of confusion about what data protection either now or under GDPR actually means. And in a general sense, not very much difference, to be honest with you. GDPR doesn't change much, but what is worth pointing out are that there are certain pieces of business data that could be considered personal, which therefore means that if personal data, which is defined in the Data Protection Act and the GDPR, if business data is personal data, then there's certain rules that need to be applied. Probably the key one, and something that a lot of people don't realise, is that if you're a sole trader or a partner in a partnership, or certain types of partners, then your data is actually personal data. So if you do business with mainly sole traders, or there's a chance that there's sole traders amongst your say your marketing data, then in theory that is personal data, and should be treated as personal data in the eyes of the data protection rules. So in terms of GDPR, that now means that your sole trader data, you need to make sure that they've given you the proper consent to actually process their data for the purposes of which you've collected it already. Now, even business data, so a clear business, non-sole trader or partner data, even that is governed by regulation, and is often misconstrued. That, as I said, that business data isn't considered something you need to worry about from a data protection point of view, and therefore marketing rules don't apply. As I say, even under data protection rules, you have to have a certain amount of consent before you can market to consumers or market to people who have given you personal data. But actually, there are rules which fit within the privacy regulations that also control how business data is processed, and certainly for marketing purposes. So if you have an email address of an individual and it's their business email address, then that is personal data in the eyes of the GDPR going forward, and therefore needs to be considered and treated as personal data. But the privacy and electronic communication regulations do allow you to market to those people as long as it's relevant to their role and you provide them with an opt-out. More generic related data, so accounts at a business, for example, you could get away with marketing anything to them, provided that it can be there's an opt-out as well. So the key for any business, clearly business data, whether it's an individual in the business or a generic email address, is that you need to provide an opt-out. If it's an individual's specific email address, then you need to be treating that as personal data, and you need to make sure that the marketing you're doing to that email address is indeed relevant to their role. So that's a very brief cover of when B2B data is actually personal data, which is something that, as I say, a lot of people don't always realize. So where does that take us into privacy, which is our second challenge? So the first challenge in B2B compliance is recognizing that certain types of data is controlled and managed under the General Data Protection Regulation or data protection rules. The second challenge is something that I've already touched on. It's the privacy regulations and how they apply to marketing compliance in the B2B world. So in the UK, we have the Privacy Electronic Communication Regulations, which or PECA, which govern how certain types of data is controlled and managed. And typically, the PECA got a lot of high-profile coverage because of the rules and implementation of around the use of cookies on websites. So that's where that legislation. So that's the regulation and legislation that controls the use of cookies. As I said on the previous slide, if you're using generic business data for marketing purposes, then provided you allow an opt-out, so the end user can opt out of receiving further marketing, and you honour that, then you can pretty market to your heart's content. But there is so in the consumer world, there's a thing called the telephone preference service, for example, which is for telephone marketing, and you should clean your consumer data against that list to ensure that you're not marketing to people who have opted out of receiving cold calls. There's also a corporate telephone preference corporate telephone preference service, which is the CTPS, and you should also, if you've got telephone numbers for business data, then you should also be cleaning that business data against that corporate telephone preference service. And if people are on that list, then that means they've said they don't want to be cold called, and therefore you should avoid calling them. And the thing to think about actually is, whilst I say if you've got business to business data and it's generic business data as opposed to an individual, and even an individual, as long as it's relevant to them in their role, you can market to your heart's content. Well, yes, you can in the eyes of the law, but you need to reflect and think about how that might impact the view of your business. If you're constantly seen to be pestering people by sending them unwanted marketing material, ignoring their choices to opt out, for example, then you might get a bad reputation, and people might start saying, well, don't bother with them, they never honour any of the requests and things like that. So think about reputation and brand awareness around these kind of things as well. And as I said, if you've got an individual's email address within a business, then you must consider that as personal data, but the Privacy Electronic Communication regulations allows you to market to those people with things that are relevant to their role, and provided you provide an opt-out as well. So you need opt-outs in all senses of the business-to-business data. It's just that the only control you need to think about is if it's a personal email address. So mark.gracie@digitalcompliance.co.uk would be a personal data for the purposes of defining the data, but because it's a business email, then provided it relates to what I do in my business, then you can mark it to me. If you contacted info@digitalcompliance.co.uk, then that's more generic and you can market anything to that. But there are also other changes on the horizon in the form of the privacy regulation. The e-privacy regulation is an updated version of the directive that led to the Privacy and Electronic Communication regulations. We're not quite sure what that might look like. One has been, an updated draft has been adopted, but where we're going with that is unsure. What we are told is that the EU want it to be going live on the 25th of May 2018 at the same time as the GDPR, which is going to be a bit of a challenge for them, given that that's less than a year ago away, and it took them 7 years to debate the GDPR in the first place. So we're not quite sure what's going to happen with that. But just before Christmas, a leaked version, a version was leaked, and that implied that there were new rules around B2B marketing. Now, these rules have apparently been withdrawn, but it's certainly a piece of regulation to look out for, not least of all because it could be changing the legal area around B2B marketing. Probably the biggest change might be the way that cookies are managed, and we might have some better clarity around cookie management going forward, rather than the rather laughable approach to cookies that we've got right now. So there's your second challenge, privacy rules around how you can market, but also sort of an additional challenge to that is look out for the privacy regulation. It could be coming to the UK as a new EU law at the same time as the GDPR, and again, because it's a regulation, it will cover the whole of the European Union, and who knows what's going to be in there in the final version. And let's just hope that there aren't rules around how, or more stricter rules around how you can market in a B2B environment. And then my third and final compliance challenge is around security. I'm pretty sure that most businesses will be aware that there are security risks. It wasn't that long ago that quite a few businesses, including the NHS, were impacted by the WannaCry ransomware. And ransomware and viruses and malware and other security risks are always going to be there for businesses. I think the biggest business challenge is accepting that there could be a risk to your business. I speak to a lot of businesses who think that they don't worry about it too much because they think they're too small, but actually there is no, you're never too small to be impacted by any particular vulnerability. So the B2B challenge is really ensuring that your business is as secure online as it possibly can. Security is a principle of the General Data Protection Regulation, as it was with the Data Protection Act as well. So you have a legal obligation to ensure that any data you're managing and controlling and storing is secure. There's lots of businesses out there that will sell you services to make sure that kind of data management is in a secure environment. But you have a duty to ensure that security is in place. And we're even seeing now with the Information Commissioner and what they're doing under the Data Protection Act that they are finding businesses who are having issues with their online presence and is impacting their business. There was a fine against a small e-commerce site probably a month or so ago now. They had a vulnerability on their website. They didn't go into details about what that vulnerability might be, but reading between the lines, it sounds like probably an unpatched version of WordPress that had a vulnerability that enabled hackers to get into the site and get access to their customer database, which unfortunately wasn't encrypted. So they managed to steal the credit card details completely unencrypted from the e-commerce website, and the Information Commissioner clearly fined them on the basis that that data wasn't secure because it wasn't encrypted, let alone the lack of security around the website. So from a data protection point of view, security is a legal obligation on anybody managing data, and even in a B2B environment, as we already talked about, that can also include certain types of business data. In terms of other areas to consider on security, you've got your online assets, which the obvious ones are your website security and access to social media, but also cloud storage and where you store your maybe your business documents or even your data. I speak to a lot of businesses who stick their data in Dropbox, for example, and assume that it's all secure. Because that's what Dropbox say, is they run or any of these cloud vendors say they run secure services. Well, of course, there's two sides to security in a cloud environment, yours and the provider. The providers are doing everything they can to ensure that their systems aren't vulnerable to attack, and therefore your data's at risk from their end. But you also need to take responsibility for how you provide access to that data in that service, and that's the same across any online platform. Website security wise, well, it really depends on how you run your website, but website security can cover anything from having sensible or secure login credentials so that people can't accidentally brute force attack your website and manage to get logged into the back end, the content management system. But there's also things to consider around the kind of platform that you're using. And I've already mentioned WordPress, and that's a very good example because it's so popular. I think it's about a quarter of 25% of all the websites on the planet are running on WordPress. Because it's so popular, it's a clear target for hackers to focus their monitoring and their skills on trying to find vulnerable WordPress websites. So if you run a WordPress website and you don't have automatic security updates turned on, then if you don't pay attention to the fact that WordPress do release security versions of WordPress to patch vulnerabilities, then you run the risk of leaving your site open to an attack. And that might not be an attack in a traditional sense of somebody hacking into your website and gaining access to your data or changing your website. It could be using a vulnerability that enables changes to your content, for example. And WordPress actually, they released 4.7, I think maybe 6 months or so ago now, and there was a vulnerability in an aspect of a new feature which meant that attackers could use the vulnerability to change the content. So people were starting to see that their website content was having strange material in it. And typically that strange material is things like pornography and illegal pharmaceuticals. So WordPress patched it pretty quickly before it went generally public, and there were a few very quick snap upgrades to WordPress to address a number of security issues with 4.7. But people didn't have security updates automatically turned on, and therefore they found that their site became vulnerable, and they reckon there were millions of sites which were defaced because of this vulnerability. So you need to have clear website security protocols within your business with regards to how you make sure that your site is kept up to date, and depending on the size of your business and your organization and how it's structured, then that will depend on what kind of approach you might take. A lot of smaller business, for example, will be thinking that their hosting provider takes care of these things. Well, you need to make sure that really is the case. As for social media, well, social media can be generally okay, but of course, if somebody gets access to a social media account and takes it over, and that could be very harmful to the reputation of the business. And also there are security risks from using social media. Occasionally there are malware installs coming off the back of people sending private messaging within Facebook and things like that, and Those are the kind of things that you need to look out for. And in a general cybersecurity approach, so that's your traditional hacking, people, phishing, people trying to get you to give them their passwords, your passwords, or trying to convince you to the email you've got is from the chief executive asking you to transfer money to pay off a bill, those kind of things. So that's CEO fraud, for example, are all things that can enter into your business through online services, email, or even through telephone, those kind of things. And it's about having systems in place to protect your business against that, and also mitigating the risk by ensuring your staff are up to date with what the latest risks are and what they might face. So that is very much about educating what I see is the weakest link within a business, which is not necessarily the technology, it's the employees. And if they're not aware of what to look out for, then they run the risk of putting the business security at risk, purely by the fact that they hadn't been shown, for example, how to dismantle an email to understand that it's not really come from who they think it's come from. So whilst that's my third challenge, a compliance challenge in a B2B environment, there's actually quite a large area there to consider, from data protection compliance through to managing your own assets online and how you protect against security vulnerabilities there, and also general cybersecurity risk, and the kind of issues will vary according to your business. Lawyers, for example, who deal with property, they obviously have a significant challenge in the fact that on a Friday they often transfer large quantities of money because they're helping people buy houses and sell houses. So there's a real risk there that they might get caught out by somebody pretending to be a vendor and being told to transfer money to a different place at the last minute. So whilst it's difficult to sort of talk about some of these things without sounding all doom and gloom or a bit scaremongery, there's actually quite an easy way to approach all three issues, be it data protection, privacy and marketing, or online security. The biggest thing on data protection is know what you're supposed to be doing from a data protection point of view. So from a general data protection regulation coming in next year point of view, that's about understanding what's changing and how that will impact your business, making sure that you have a register of your data and what data and systems and processes you have in place, and audit those on a regular basis, or at least audit them with a view to general data protection regulation compliance, and make sure you're able and have the processes in place and the procedures and the policy documents to manage ongoing compliance. And ongoing compliance isn't just about making sure that your data is secure or that you've got the right kind of data. It's dealing with individuals' rights with regards to access to the data you hold on them, or them asking questions about how you process their data, right through to ensuring that you're not storing more data than you're supposed to be, and you're deleting it when you don't need it anymore, and all those kind of things. So there's very much an ongoing process, and key to that is going to be employee training, so that they understand what they're expected to do with regards to compliance around data protection. When it comes to privacy and marketing, again, know what the rules are. I covered those earlier in the previous slide. And also know about what's changing. As I say, the e-privacy directive, e-privacy regulation could make some interesting changes and introduce some interesting challenges to businesses. And again, know your data, what kind of data it is, and if you think it's business data and therefore data protection doesn't comply, just check that that really is the case. And if you find that you can't tell that data easily, whether it's personal or business data, then you might need to have a general approach to data protection as treating everything as personal data, even though not all of it is. And again, managing ongoing compliance, the key thing there is keep an eye out for what's happening with e-privacy regulation. And then finally, on the online security, clearly make sure you've locked down the security on your systems as much as possible, and that's everything from whether you've got laptops and you've got them locked down with passwords and security, and you've encrypted the hard disk, right through to your online assets particularly around things like your keeping your website software up to scratch and secure, as well as your approach to access to internet-related services. So I'm talking about things like two-factor authentication, which is an extra password control that you can add to pretty much most of the normal or usual cloud-based services, for example. And one of the key areas is, well, there's two. One is make sure you've got policies and procedures in place so that everybody in the business understands what security should look like for them and what your approach to security is, so that they know what their role is in securing your business. And obviously part of that is training your staff so that they understand the risks. So we've talked about 3 compliance challenges for B2B businesses, those being data protection and the changes that are coming, privacy and marketing to businesses, and then the final one is your own business security or approach to security. And the thing to think about at this point is, well, how does your business, or you may want to take this back to somebody who has specific responsibility in this area if that's not you, but how in your business are you addressing these issues? How do you make sure that your business is protected and compliant? And there's a number of things you can look at. You might want to run some internal training workshops. You might carry out an audit, particularly if you're worried about the GDPR. And you need to carry out management of your approach to compliance and take action if there's some that's needed. I'm afraid here's the sales pitch. The Digital Compliance Hub is something that can help you with all of those things. The Digital Compliance Hub is a service that I've set up. It's an online service, but there's 2 aspects to it. One is it's online data and information, so you can log in and get access and find out about certain pieces of legislation and what they mean in all these various areas. You will also have access to tools. So there's a toolkit, for example, on how to manage GDPR audit and compliance. But the other angle is also the human factor. So you'll have access to expertise in the form of support, help when you need it, advice and guidance, and training materials. So there's sort of a hybrid of it's not purely an online information service and it's not purely a consultancy service. It's a mixture of the two. But obviously, if your business is thinking, well, I need to think about these things, I need to get somebody in, then we also sell consultancy services as well. And as for attending this, as a thank you for attending this webinar, if you want to have a look at the Digital Compliance Hub, you can do so for a free month using hub-free-month as the coupon at the checkout. But feel free to email demo@digitalcompliancehub.co.uk if you'd like to have a look round and be shown sort of some of its main features and get an overview of that. So that was all I wanted to cover this morning. We've got about 10 minutes until the end of the session. I'm just going to see if there's any questions. Not at the moment. Amy, I hope you can hear me okay. I was just taking you off mute, so I'm just wondering if you had any questions. Okay, I can't hear anything coming from you, Amy. So if that's because you've not got any other questions, that's fine. In which case, thank you very much for joining. And hang on, I can see you're in an open office. Okay, that's fine. Okay, well, thanks very much for joining. And if there's anything that you think of, then feel free to drop me an email at mark@digitalcompliance.co.uk, or as I say, make use of that free month on the hub. other than that, thank you very much, and we'll leave it at that. Thank you.